Debt collectors have the right to try to collect debts, but the people who owe those debts have rights too. We'll talk about debt collection and the Fair Debt Collection Practices Act right now on the LawWorks.
From West Virginia Public Broadcasting.
Closed captioning for the LawWorks is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The LawWorks is made possible by a major grant from the West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and legal system, promoting public knowledge of the law in West Virginia. By the generous support of Software Systems Incorporated, a West Virginia company established in 1975, providing high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems. And by viewers like you.
How far can a debt collector go in trying to collect money? How far do they go? My guests are Professor Matthew Totolo of the West Virginia University College of Law and attorney Martin Sheehan. Matt, Marty, thank you for being with us.
Dan, how you doing?
Thanks, sir.
We talk about debt collection. There are laws that govern this activity. Matt, what in broad terms are those laws?
Well, at the federal level, the big statutory regime is the Fair Debt Collection Practices Act. And this protects consumers from misleading, harassing tactics by debt collectors. It's supposed to prevent these tactics.
Does it?
Well, it's a good question. In the last few years, to put a context on this, in the last few years, U.S. consumers are indebted. Household indebtedness is $2.5 trillion with a T, and we're talking about consumer debt, credit card debt, and this kind of thing outside of mortgages. A lot of money, a lot of debt out there. And in the last few years, of course, we've had, the economy has been in bad state, a lot of unemployment. So there are a lot of people late on paying their debts and so forth. And this is just the last few years. So there's a lot of debt collection activity. And in fact, an industry has emerged that is, some say, over $50 billion a year industry in terms of revenues. I've seen those numbers. 200,000 people employed in the industry.
In collecting debt.
Yes, these are the numbers that you hear.
These aren't the debt creators.
Correct.
They just come to get it out of you.
This is the industry, right, that exists now to collect debts. And so there's a lot of, obviously with that much activity, even if everything was working the way it was supposed to, there'll be problems.
Well, you used the word harassing. Harassment tends to be in the eye of the beholder. What are debt collectors allowed to do? Can they call me every day? Can they call me every hour? What?
Well, they can certainly call you repeatedly. They can call you. There's not necessarily a fixed bright line for a number of times they're allowed to call you, but courts will look at this and will judge each case by its facts. And they're certainly allowed to call you more than once, and they can call you repeatedly. But at a certain point, it becomes harassment. For example, very early in the morning, before 8 o'clock, and after 9 at night, that would be under the statute harassing behavior. Calling you at work when the debt collector knows they're not supposed to do that would also be harassing.
How would they know they're not supposed to do that?
Well, ultimately the consumer would just tell them, I'm not allowed to take calls at work.
Right.
So there are some obligations on the part of the consumer.
Well, you can say, don't call me at work, and professors pointed out that there's a federal statute. The federal statute really is a basic minimum. A lot of federal legislation prohibits competing state legislation, but that's not true in this area. In this area, there are state laws that are allowed to be more strict on what the obligations of debt collectors are. West Virginia has such a statute.
In many cases, the federal government, Congress will pass a law, and say this is the way we're going to regulate this, or this is the way we're going to do that. And states are not allowed to pass laws that touch on that. And we call that the doctrine of federal preemption. Once the federal government gets involved in an area of law, they control the law of that area. But in this case, states are allowed to have their own laws too.
They've been very, when Congress passed the Fair Debt Collection Practices Act, they were very clear that states could have more serious standards. And in certain respects, West Virginia's standards are a little bit more exacting for debt collectors.
How so?
Well, one of the things is damages. The Federal Act was passed in the 70s, and there's a statutory damage amount between $100 and $1,000, depending on what the court finds is the problem.
For a violation of the Fair Debt Collection Practices Act.
Right. West Virginia passed the statute about the same time, and if you read the language of the statute, you'll find pretty much the same numbers. However, West Virginia indexed that number for inflation, and normally today that number is between $450 and $4,500. And so that's a pretty significant change in the amount of enforcement power that the consumer has.
Well, I'm getting calls from debt collectors all the time. I want that to stop. How can I stop this?
Well, right. There are a few things. There are a few things that you can do. I mean, if you're getting calls, first of all, you can just tell the debt collector, I do not want to be called anymore.
Does that work?
Well, sometimes it does, sometimes it doesn't. But you have a right. If you say that, of course, you don't want to put that in writing, and we can talk a little bit more about that. But if you tell them not to call you, they're not supposed to call you anymore. Now, that doesn't leave them without a remedy. They can still sue you in court for the debt, but it should, at least the statute contemplates that the debt collector will then stop calling you.
You have to put this in writing?
Well, it's the best practice for you to put this in writing. You want to actually, put this down. Actually, send it by registered mail. A lot of debt. For example, if this comes to a lawsuit later, you're going to want to have evidence that you actually asked them to stop and they continue to do this.
So you have to engage with them enough to know who they are, where they are, so that you can send them something that says stop.
Right. I mean, a verbal communication over the phone should be enough. But in terms of really,
with a responsible debt collector, it is enough, because
right.
I've been in some litigation settings, and you'll ask for the exchange of call information, and you'll have gotten that, and it'll say debtor asked us not to call anymore, and pretty much you'll see a discontinuance of those practices, and that's, when I'm in a case where we're suing someone and that appears there, it's more likely that the damage number, assuming that there still is one, is going to be at the lower end of the scale.
Now, we did not talk about what Marty does in his practice. You have a practice that emphasizes, at least to some extent, bankruptcy law.
I am a bankruptcy trustee, and so I make a living with bankruptcy. Other parts of my practice are a hobby, Dan, but bankruptcy is how I make a living.
Right. So you see people who are seriously in debt. I have a rather general practice. I hear from people who are getting phone calls from debt collectors and who are unhappy about it. Now, the purpose of the show is not to tell you how to beat paying your debts. The first rule is if you owe somebody money, it's a lawful debt for a lawful service or product, pay the debt. What happens, though, is people get behind, they lose their jobs, their house burns down.
They get sick.
Right.
They get sick or injured, and you just can't. So what we want you to understand is what your rights and what your obligations are also. So if you're getting phone calls, you don't want the phone calls are fruitless, you tell them, don't call me anymore.
Right, that would shut down, and for above the board operations, for legitimate operations, that'll often be enough, right? That'll often be enough. But it's often the case that it will not. And
the other thing you want to do is get on the do not call list for the federal government has as well. And so.
Yes, and you can find that on the internet. Do an internet search for do not call list, and you'll find out, probably you'll go right to a website where you can enter your phone numbers for do not call. Debt collectors have to honor the do not call list.
Yes. Right, and the other thing I wanted to mention was, because phone calls are it's only one time when the debt collector is contacting you that's of concern. The other time is when they're sending you letters, and that's another issue that comes up in the litigation a lot. So debt collectors have an obligation. There's a series of, it's a highly regulated area, so the debt collectors have an obligation to communicate to the debtor what the debtor's rights are in that situation. And they have an obligation to verify the debt, to actually find out if the debt is in fact valid. So This is actually a frequent source of litigation these days in terms of how much the debt collector has actually communicated this, how much they have actually honored this. So this is another source of litigation.
Well, and that imposes another duty on the debtor too. Is the debtor has to say, it's in essence, prove that I owe you this money. Send me a statement of the account. Show me how this was incurred.
Sure, and if you make that request of a debt that's really owed, people generally can send you an invoice very quickly and verify what that is.
Right.
In my practice now, what is pretty common for people who talk to us about filing for bankruptcy is we start to send out letters to people and ask them to tell us, give us some current statements about the debts, and then in my practice we ask people to people you might owe money to to communicate with me going forward. West Virginia law requires a person who's invoked the aid of an attorney in that way to have that request honored, and then to have all further communications with the attorney. So.
We're talking about debt collection. My guests are Professor Matthew Titolo of the West Virginia University College of Law and attorney Martin Sheehan. I'm Dan Ringer, and this is The Law Works. But, okay, you tell the debt collector, don't bother me anymore. And you may even say, I can't pay this. The roof fell in on my house. My husband blew up, whatever it was. I can't pay this. Don't call me anymore. That's not necessarily the end of it.
No, it isn't. This is, again, assuming that it's a valid debt, which in many cases it will be.
I would assume in most cases the debt's valid, at least at some point in its history.
Well,
most cases.
Well,
I'm not so sure,
I'm not so sure of that either.
Okay, inform me, enlighten me.
Okay, well, I mean, there's, again, given the numbers we were talking about before, and the debt collection industry estimates that it has 1 billion contacts with individual consumers, with consumers each year. It's a lot of contacts, a lot of mistakes are going to be made, and when what we're dealing with here is like the debt collection industry. It's very complicated. So just like the mortgage industry got into this securitization issue where the debts will be bundled and sold to third parties, and very often the third parties won't have the documentation of your individual debt. In many cases, you're seeing an attempt to revive old debts that are long since time barred.
But the issue here, Dan, is that some debts will get so old that they're barred by the statute of limitations.
That's right.
You also have debts that were discharged in bankruptcy. Some people will come back. And really, that's how the bankruptcy lawyers have gotten into this issue. And one of the things that has emerged that we started talking about is something we call zombie debt, kind of casually. But what it is, it's debt that's dead. It's legally unenforceable. And the industry will try to take some action to get people to make a voluntary payment. And that theoretically can revive the obligation to pay.
Okay, let's go back and look at these. Statute of limitations. Generally, a statute of limitations is a time period after which nobody can complain about whatever it was that happened, be it a debt, an automobile accident. What's the statute of limitations on debts?
Contracts in West Virginia, it's 5 years for an oral contract, 10 years, I think, for a written contract. So it's a long time.
So if it's a credit card deal, it's probably a written contract. It's going to have
Yes.
a 10-year life.
Right.
And if it's just, I'll buy that pencil from you, I'll give you $5 for it next week, that's an oral contract,
Right.
and it's going to be a 5-year
Right,
statute of
and
limitations.
quite honestly, you would think that if there's going to be debt and it's going to be an issue and it's not been paid, that's a pretty long time and you'd expect it to be resolved. But you'd be surprised at how much debt that's floating out there, and I won't even call it debt, I hate to call it that because it's unenforceable, that is still floating around on somebody's books and they're like, we'll try and get some money out of it. And what's unfortunate is these are debts that may be worth thousands of dollars and they were sold for pennies. And so any recovery at this level is really kind of random and found money. And my real feeling, and I don't have the statistics the professor has, but my real feeling is that the further down this chain you go, the more aggressive and the more unscrupulous debt collectors are prone to be.
So you talked about securitizing or bundling these debts together. What is happening is a business, might be a big business, might be a small business, has what are typically referred to in the business world as accounts receivable, money that is owed to them. They take all of their outstanding collectible, or all their outstanding debts, and they will sell them to you for pennies on the dollar.
Exactly.
And you're free to go ahead and try to collect them.
Yes, and often this happens at the wholesale level. We're talking about hundreds or thousands of accounts that are essentially bad debt, this zombie debt, sold to a third-party debt collector whose business it is to then try to collect on these debts. And it's very confusing for consumers who might be receiving calls from parties they have no idea where this debt comes from. And sometimes, unfortunately, the debt collector who bought this portfolio doesn't know where the debt came from either and doesn't have documentation to back it up.
And hence identity confusion, because these debts are old, people move. They may be just calling everybody in the phone book named Mary Doe.
That's a good point, yes.
Looking to find the right one, and they don't accept, I'm not that Mary Doe, for an answer.
Right. No, exactly, right. And this is in a large number of these cases, I don't have the figures for this, but a good chunk of these cases have to do with mistaken identities. And the fact that you're saying I'm not Mary Smith is not going to stop. Many debt collectors will not just take your word for that and just stop there.
No, that would be too easy.
That would be too easy.
We're talking about debt collection. My guests are Professor Matthew Totolo of the West Virginia University College of Law and attorney Martin Sheehan. I'm Dan Ringer, and this is The Law Works. Well, you can stop the calls in theory by saying, don't call me. You can stop the calls in theory by saying, talk to my attorney. And you can stop the calls, I hope, in fact, by filing bankruptcy if your debt is that serious.
And I'd like to tell you that that one's foolproof, but I was at a conference recently and I found out the debt that's actually legally unenforceable in the bankruptcy setting is still, there's a market for that. And that just surprised me to no end, because there's a court order that says leave these people alone. And that just, the fact that anybody would try and traffic in that after that is just stunning.
Well, if they know that that's what they're trafficking in. If I have a bunch of bad debts on my books and I want to get some money for them, I'm going to sell them to you for 2 cents on the dollar, and this really, a penny on the dollar, 2 cents on the dollar is not unusual.
I think it's fractions, Dan.
And, and if the accounts are big enough, it could be fractions on the penny. I'm going to sell them, and I may not tell you, Marty, that these people filed bankruptcy.
Well, and at some point, and that may be, but that's fraud by you. Okay, and so that's the thing that you would expect the debt collector who's been frustrated and has found out the person has filed for bankruptcy would come back and say to you, you can't sell me this worthless garbage. But the reality is people know it's worthless garbage and are actually willing to pay for something that's really nothing. And I have a real concern about this entire practice in our economy.
Well, and that's where the nasty aspect of debt collection comes from. Because the people who have bought these debts are, in a very real sense, desperate to collect them, so they start to use really intense strong-arm tactics against the debtor to cause them to pay up. Even if the debt is 15 years old, even if the debt is not yours, at some point the thought goes through your head, I just want it to stop. Make it stop. I'll send them a check for $100 or $200 or something just to make it stop. And the debt collectors can get really, really outrageous.
Absolutely.
And that's your cue, Marty. You had a case where this happened.
I'll start off and say the easy problem is that what you normally get is you get somebody who calls up and says, we have a case. They don't refer to it as a project, or they don't refer to it as a debt. They refer to it as a case. They'll say, you're required to call back. They try to create a sense of obligation. And those things are misleading. If there is a case and they're going to sue you, that's fine.
Well, but in our world, a case means somebody's gone to a courthouse and paid a fee and gotten a case number, and
they filed
there's a case.
And a summons will arrive either in the mail or with the sheriff. I mean, and that's pretty simple, and that's what it is. But there's but debt collectors don't want to go to the expense of hiring lawyers and don't want to do that. So they use the phone in an effort to try to create a sense of obligation and that kind of thing, and that's where you can get started. And I've had several cases like that, and as a trustee, I've employed attorneys in other cases, and we've collected monies like that. But it can get a little bit more serious, Dan. Yes, it can.
How serious can it get?
Well, I was contacted, I think a year and a half ago, by a woman who got who received a call like that. She has described herself occasionally as an accidental activist. She's occasionally gotten involved with trying to enforce her rights. And she sent out a letter and said, leave me alone, and by the way, you owe me some money. And
we should point out that this woman was not the person that owed the debt.
Well, that's true.
Nor was anybody in her family.
They said the debt might have been her son's, but we're not really sure. He hadn't lived in the house for a long time, and so it was just it was a little bit random. And she is more vigilant about her rights than a lot of people are, and so she took action. She did engage in a little bit of self-help. She knows when that letter got delivered, and minutes later, she received a call that everyone on the planet would describe as obscene, Dan. And so,
where did the call come from?
Well, I'm now going to use one of these new terms that I just learned. The term's called spoofing. And apparently, and there's a certain irony to this, but you can make a phone call and cause a number that's not the number of the caller, but some other number to appear on the caller ID. And so that practice appears to have been employed. And my client thought she got a call from the Ohio County Sheriff's Office, which is where she lives. We have some indicators that this company has made calls around the country where they've purported to be, and related companies have purported to be either clerk's offices or sheriff's offices or a number of things, and there's a lot of postings on the internet that are associated with a particular phone number that say that, that's a practice that they've engaged in.
And this call was over the top.
Yeah, Dan, I gave you a copy of the transcript today, and the
yes,
professor...
I'd like to read this transcript to you, but the Federal Communications Commission would take us off the air before this program is over if I tried to do that.
There's only one sentence that's not offensive, and the entire transcript that's by the caller, and it is, I think your husband would enjoy that, and you have to go some distance to find that one, Dan.
Well, actually, I read the transcript, and the only comment from the caller that I can find in here, well, I can't. there is nothing in here that I can read.
No, Dan. To say that there are four-letter words and references to disgusting sexual acts are replete through the thing, that's where it is. She has reported being afraid, and that's not a surprising consequence of what after you've read this.
Well, she got this call, and she did become afraid, and her family responded and came to her aid, literally physically, in response to the call.
Her husband was out of town, but her son came over, and she called her husband, and she ended up moving her husband's gun from where they normally keep it to keep it on the bedpost just in case. I mean, it was a really kind of a frightening reaction to just a phone call, and unless you've gotten a call that's just that over the top, it'd be a little shocking.
Well, and her husband cut a business trip short and came back.
He did come home.
And you sued them for her.
We did.
What happened?
Well, although we had some substantial contact with people who said they represented them, no one actually came forward. And we ended up getting what lawyers refer to as a default judgment, which is when they didn't answer us, we won. And then we asked the judge to establish a level of damages based on the conduct that had occurred.
You had a hearing and you presented some evidence about what happened. The judge made inquiries as to the amount of the damages, and in this case, most of the statutory damages were in the thousands of dollars range.
He awarded, I think, the maximum statutory damages he could under the relevant statutes. In this case, we also added some claims for West Virginia recognizes what lawyers call torts or claims. And we recognize two claims here in West Virginia, one for intentional infliction of emotional distress, and a second claim, which we recognize as and we call the tort of outrage. And while that's a little confusing and a little hard to quantify, the tort of outrage sort of means you've engaged in outrageous behavior designed to hurt somebody.
And this behavior was so outrageous that ABC News and the Wheeling Intelligence or Wheeling News Register published an editorial saying sometimes you just want to punch somebody in the mouth as the lead. You got a verdict or a judgment. What'd you get?
$2 million in compensatory damages, $8 million in punitive damages, and some additional damages. It's a little over $10 million, Dan, and that's where we are with the verdict. And I'm told that's the largest verdict of this kind in the country, but when you read the transcript, it doesn't come as any real shock to you why that was awarded by a court.
And the whole purpose of the outrageous, horrible phone call was to intimidate the debtor so that she would cough some money up on a debt that she didn't owe and that had not been proven. Professor Matthew Titolo, Attorney Martin Sheehan, thank you, gentlemen, for being with us.
Thanks for having us.
If you get these calls, call an attorney. They can be stopped. If you don't owe the debt, there are things that can work for you. Thank you for joining us. On behalf of the LawWorks, I'm Dan Ringer. Good evening. On the LawWorks website at thelawworks.org, you'll find a listing of recent The LawWorks programs, additional information about this show's topic, and video of this and recent shows. You can also find the LawWorks programs on YouTube and iTunes. If you would like to suggest a topic for a future The LawWorks show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us email at thelawworks@comcast.net or visit us on Facebook.
The LawWorks is produced in cooperation with the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law. The LawWorks is made possible by a major grant from the West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and legal system, promoting public knowledge of the law in West Virginia. By the generous support of Software Systems Incorporated, a West Virginia company established in 1975, providing high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems. And by viewers like you.
From West Virginia Public Broadcasting.